in a COVID atmosphere. But what it means also is that every ministry, every department of government must have information accessible under Section 4. Again, what is a public authority? And in this matter, you all know what public authority generally means, and it is defined in the Act quite clearly. But it also includes, and I would draw your attention to this, any body owned, controlled, or substantially financed, or any non-government organization substantially financed directly or indirectly by funds provided by the appropriate government. This is in keeping with what I was explaining earlier, that if the government has the right to any information from any institution, that right is shared by you and me as citizens of India. Now, right to information includes the right to inspect works, documents, records, take notes, extract or certified copies of documents or records, take certified samples of material used in building roads to ensure that it is in fact in keeping with the tender in building roads in any other form, and obtain information in form of printouts, diskettes, floppies, tapes, video cassettes, or in any other electronic mode or through printouts. So this is a law based strongly on the whole basis of information.
So we have a question over here by the audience members as well. If I can prompt it to you.
Please.
Yes, sir. So the question is...
Should I conclude my discussion
sure,
now?
sir. Definitely.
And then we can go into questions.
Absolutely,
okay?
Sir.
So I won't go into details of what penalties are and all that. You already know all that. I will only conclude by saying that this law...
Sir, we have enough time. Once actually what had happened in between, we broke. So you can continue. I mean, still now again...
in any case, I was coming to my conclusion.
You take your time.
I don't need to go into details of penalties. I think you're all quite aware of that. So rather than going into details of what the penalties are and how you qualify for those, let me go straight to the question of what are the responsibilities of public authorities, and therefore what is the essential of e-governance. And that is the public authorities, their responsibility is, as I mentioned, ensuring that information which is supposed to be in the public domain under Section 4 is placed in the public domain. And this is where people like you, and particularly lawyers, have this responsibility of ensuring the government is actually doing what is required by the law. History, as you know, now has its own website. You can easily access those websites. But the question is, do those websites provide you information? And information means, I remember speaking to Dr. Abdul Kalam shortly after, a year or two, in fact, after the law had been enforced, and to his great enthusiasm at that time. And I said to him, sir, now you'll be very happy to see that every ministry has got its own website. He said, yes, they've got their own website. But am I getting any information? Because they've got all old information on the website. Now the law demands the website is to be updated every 120 days. Is that being done? It is the responsibility of the ministry itself to ensure that. But when I told you earlier, it is also the responsibility of the citizen. Isn't it the responsibility of the citizen to monitor the updates on their websites in areas which may be of interest to you as a lawyer? And if the ministry is not complying, is it not your responsibility to bring it to the notice of the ministry that you're not complying with this? Government is expected to publish all relevant facts while formulating important policies or announcing decisions which affect the public. This is section 4.1c. What is the objective of this? The objective of this clause is to make the public participants in policy formulation. Because when the government brings out policies that we are formulating such and such policy, here's the grounds. The public, the NGOs concerned, or the lawyers concerned, can come back and say, well, this assumption is faulty, or this factor has been ignored, and therefore take all that in actually formulating the policy to make that policy more effective. So the responsibility of the public authorities means that it has to provide reasons for its decisions to all affected persons, provide information suo motu, raise awareness by educating and training not only its own employees, but members of the public under section 26(1), and compiling in 18 months and updating regularly local languages guide to information. Is this being done? All these things are there. But e-governance has certainly come. E-governance has come in a large way, as you have mentioned, Mr. Chadha. But what are the inadequacies? A workflow system has been devised by the National Informatics Center for the RTI application and response, first appeal and second appeal. It's also being used. But is it being used across the board? Are the courts using it? Supreme Court now, and I know I've had occasion to discuss this even with my friends among the judiciary. And they have, of course, said that we would like to use this, like video conferencing and so forth. But it is not present adequately. Records, the computerization and access to records has been taking place. Standardization of procedure has been taking place. But is this to the extent it is necessary for e-governance? We do know, and our Prime Minister has reiterated frequently, minimum government, maximum governance. What is maximum governance? The meaning of maximum governance is the participation of the public in governance. And the key to that is RTI. So the questions that you should be asking yourselves and the government is the government standing up to its responsibilities? Are we standing up to our responsibilities under the RTI Act? And herein, coming to a conclusion, I will take you back to the pronouncement of none other than the Supreme Court of India in the state of UP versus Raj Narayan. As you will remember, 1975, the reference is 4 SSC, 4 SCC, 428, and Justice Matthew, on behalf of the bench, said the following: in a government of responsibility like ours, where all agents of the public must be responsible for their conduct, there can be but few secrets. You will recall what I told you about Justice Brandeis, and here is our own Justice Matthew. The people of this country have a right to know every public act, everything that is done in a public way by their public functionaries. To cover with a veil of secrecy the common routine business is not in the interest And as you remember, this is the law on which, this is the ruling on which Supreme Court has repeatedly relied in declaring the RTI Act to be a fundamental right. So thank you very much. And I think you had given me 45 minutes, and I have taken those 45 minutes. So at the risk of putting your audience to sleep, I would now like to leave the floor open to questions.
Sanjay sir, you're muted. Can you unmute yourself?
Thank you very much, sir. It was indeed very enlightening. And I would request Bhumika to please put the questions. And because of this technical glitch, I don't know what had happened. This entire, there was a disturbance. But anyways, now we are back on track. So I would request Bhumika to please start with questions which the students are asking.
So we have the first question, that is, how has RTI brought a significant change in the working of bureaucracy in India?
If I may go back to the earlier slide that I had mentioned to you, the question of e-governance, the working of bureaucracy, basically how it has brought about a change is the question of, just a second. Basically, how it has brought about a change is that when I joined the service, for example, we were taught, and it's part of our training, that the information which we hold as government officials is virtually a sacred document. It is held in trust. And the principle is the same. It is held in trust, but under no circumstances must it be disclosed unless compelled to do so. Compelled to do so would mean a judicial pronouncement or some such compulsion. Now, the thinking is, and I think any government official will tell you this, that now the thinking is that any information held by government, unless it is excluded from disclosure, should be disclosed. Now, people may find ways and means of not disclosing for ulterior motives, but it is accepted in government that information that is held in trust, yes, but in trust not for those in authority, but in trust for the people, and therefore must be disclosed. In practical terms, what has this meant in the change in functioning of government? On the one hand, the functioning of government is much more coordinated. I told you I had experience of working in government where one ministry, in the same ministry, two departments were working on the same subject without realizing that in the same ministry it is being dealt with by another department. Why? Because they did not exchange notes. Everything was held within their own department. When people started asking questions, and one gave the answer that this is secret information, can't be disclosed, the other gave the answer. So the appeal came that this PIO has deceived me by saying it's secret information. I then, when I saw the records, I said, no, the PIO has not deceived you. Because according to his classification in his department, it is secret information. In the other department, that is declassified, same information, same subject. And the two ministries, the two departments were dealing with it in different ways. As you can guess from the fact that one considered it confidential and the other didn't consider it confidential. So this is now what is happening. There has been, as I told you, every department has now become more transparent because each department has its own website. Now you can go onto the website and sitting at home, you can at least this much you can do. You can find out as to which department or which section of that department is dealing with a case in which you are interested. Earlier, you could not tell that. You have to go to the ministry, move from office to office to even discover where your papers were being looked at. Now you don't have to do that. There's also standardization of procedure. In earlier times, this procedure was not standard. What papers go to the finance section, what papers go directly from the undersecretary to the secretary, all these were undetermined. Now it is determined that this kind of paper will move in the following direction, which makes it easier for the public to actually access it. Because I can say, well, I can approach some Mr. X that look, according to the website, you are the one dealing with this particular subject. I have a particular paper in this particular subject. Please give me the answer. Earlier, you could not do this. I said, earlier you'd have to do that by going from office to office and finding out where kagas kya hua. And then probably have to pay 5 rupees here and 10 rupees to find out where exactly your paper was, if you don't finding out the information. So that, of course, has to change.
Indeed, sir, very well answered, I must say.
Yeah,
Sir,
Bhumi.
sir, prompting the question to Mr. Sanjay, sir, as well. So we have a question that why is there such immense demand to add the public sector, the private sector to be specific, within the ambit of the RTI Act?
No, sir has very rightly said. If I, sir, this question is put to me.
Yeah,
So
go ahead.
I feel your discussion, as what sir has said, has rightly said that more or less it almost everything is now covered under it, and you will not, even if I talk about banks, if I talk about private banks, private insurance companies, they are very much covered. They have their own banking ombudsmen are there. Then even as far as this thing is concerned, what you call insurance ombudsmen are there. And even in any field, let's say I give an example of there was one industry in South Mumbai where it was creating a lot of pollution. Now, what had happened that for all the data, what they did, later on a PIL was also filed in that case. Now, how they roped in them through the agency, Environmental Protection Agency, there, the state government subject, stating that, look, this is the body which is causing this. So they you can rope in a private individual through the government authority. That's what and I don't feel even a single person would be spared, if at all. We have got various other ombudsman kind of bodies are also there, which are regulating the private individuals. So that is also as good as RTI. So that is what is the answer. But still, there is a demand. They want a specific inclusion of private bodies. Sir, please throw some more light on it, sir.
No, there's no further light. I think you said the right thing. The point is that our laws are such that private bodies have in any case to report to government one thing or another, and what
Correct.
they have to report to government is accessible under RTI Act. The
Ah,
point is that the private parties may not have an institutional structure for providing information. You have to get that information through the government structure. You have to go to the government and say what is the position insofar as that private body is concerned with regards to
exactly.
the question that you asked. So it would be in fact more practical if the private bodies themselves had an infrastructure to answer questions. That would make it easier for the private bodies themselves, not that it would necessarily be an infringement. Also, as you know, there has been, because of the RT Act, a demand for transparency all across the board. And even earlier, in private organizations, the shareholders and others are supposed to having access to all information concerning that private company. But the fact was it is not even working like that. Now, shareholders are more conscious. And you will realize that after the RTI came into force, there were all those scandals and scams that broke out in private companies, where the private company was not disclosing to the shareholders the actual information regarding their own company. But the
Correct.
question regarding asking those questions within those companies actually sprang from the experience of the RTI. So beyond its own boundaries, the RTI Act has had that effect. on private sector companies. Inclusion of in the South Africa Act, private companies are included. In the new Bangladesh law, which I had a lot to do with because I was head of the Commonwealth Human Rights Initiative, and we actually advised them on that law. They have covered the private companies, but unfortunately, it is not working very well because the private companies also have a lot of private vested interests, and
Correct.
so they don't allow. In South Africa, it's not working so well because the cases, they don't have an information commission. Cases regarding private companies, they go to the normal courts of law. And the normal courts of law uh, are therefore susceptible to pressures, as are ours. And therefore, you don't have any separate mechanism, separate institution like an information commission to deal with those cases. So those are the weaknesses there. So different countries are trying out different things, but you are right. In the final analysis, in our country, this law will have to be extended to the private sector also, but provided the government, the public sector starts complying fully with the laws, particularly Section 4. If it starts complying fully with that, then then it will have the information commissions will have space to work with the private sector companies. At present, it is physically not possible.
Correct.
If private companies are also included in the same way as the public sector is, then the information commissions will not have time to look right or left. They will not have time to be able to dispose of the cases. As it is, the tendencies
Is very
have,
high.
have gone very, very high.
There's no doubt about it. The same is the case of the judiciary. That is the reason we in judiciary we say that we should go for ADRs, alternative dispute redressal system. We should adopt something of that sort. So that mechanism. But certainly, but it as we say, I can very well say that it is this law has given strength to the very small person. Individual is being empowered with this law. So certainly we have to see that this remains there with,
And
and
Chaddaji, that's right, as I've been repeating throughout, that places a specific responsibility on lawyers, on you, because you have
yes.
to explain to that poor person who will not be able to understand this himself that he has this right and he must exercise. It
And
is you who have to explain.
I would like to add one thing here, sir, that is the reason, all of us, all the law students who are listening to me and sir, and each one of you have to spread the awareness. You have to awaken these people, masses. They don't know about it, as rightly sir has said that the RTI is for us. We must know how to use it. Otherwise, the persons against whom we have to use this instrument, they keep on misusing the entire system. So we have to now wake up. We have to go to each one of us by making the law, as somebody has very rightly said, that the law should reach the जन जन we have to जन जन तक पहुंचाना है. If we till the time this law reaches जन जन, एक एक आदमी को ये इस चीज का एहसास नहीं होगा कि ये मेरी शक्ति है, इससे मुझे मजबूती मिलेगी, तब तक मेरे को लगता नहीं कि we have achieved the goal of this particular law. So it is our foremost duty to put this in front of, and that's what as far as I am concerned, I feel I try my level best to spread the legal awareness through the medium, whatever medium I get. I try and talk to the students, I try and talk to the lawyer, masses, wherever I get an opportunity, I use it. So, Bhumika, next question.
Sir, the audience really wants to know sir's opinion on PM Relief Fund not being covered under the ambit of RTI. So,
Sir,
what is their take on the same?
Well, on that, my answer is very simple. I have, in fact, made a ruling in the Prime Minister's Relief Fund.
yeah,
At that time, there was, and the Prime Minister's Relief Fund is still there. Now you have PM CARE. But in the ruling on Prime Minister's Relief Fund, and I might mention that even at that time, the Prime Minister's office and the PM Relief Fund had resisted the law being declared, the PM Relief Fund being declared a public authority, but I had ruled that it is a public authority. And basically, without going into details, the answer is very, very simple. What is the title? PM Relief Fund. PM a private institution? PM is a public institution. If it's a Prime Minister's Relief Fund, it's a public authority. Similarly, if it is PM case, it's a public authority. If it's the organization is called Modi Cares, then you may say that well, it's a private foundation in the name of the Prime Minister. But it is PM Cares, Prime Minister. I have therefore said, and the rulings are very clear on this, so there's no argument. The matter is now, of course, sub judice, but in my view, there is really no argument in this case.
Sir, I would like to add here, the answer to this is that we have to challenge that the
Yeah.
order passed by
But
the.
please understand that there's a qualification. You have mentioned various exemptions. So, like any other public authority, if PM Cares is declared a public authority, it should also be subject to the same exemptions, which means fiduciary relationships will still be exempt. That means how much I have donated, and I had held this in PM Relief Fund also, how much Wajahat Habibullah has donated to PM Cares is not open to disclosure. I may say that no, that is fiduciary information.
Yes, exactly.
How
And
much I have donated to PM Cares is fiduciary. But to say that PM Cares itself is not a public authority, that is wrong.
that is
A
wrong.
particular type of information, you can argue that well, this type of information falls under the exemption clause. And you can argue that.
And that's what your previous judgment, 2009, if I'm not wrong, 8 or 9, somewhere.
Maybe 8 or 9.
Yeah, so that judgment is very much applicable. I mean, facts are almost similar, if I may say so.
Correct.
And I think the outcome would be also the same. uh, I think Harsh has some question. Harsh, would you like to ask yourself?
Yes, sir. Like if you allow.
Yeah, yeah, please
A
do.
very good evening, sir. Uh,
Okay.
Sir, in 2007, the Puducherry State Information Commission was abolished by the order of Home Ministry. And like in the order itself, no reason was given for such abolishment. So like on the basis of the law that exists, like that we have right now, can such abolishment be justified?
And now, Harsh, you'll have to forgive me unless I study the decision. I will not be able to tell you whether it is justifiable or not, that particular decision. But in broad terms, let me mention that union territories, Puducherry is a union territory as far as I know.
Right, sir.
The union territories come under the Central Information
Yes, sir.
and states have their own information commissions. That is, in fact, the law. There are two categories of information commissions,
Yes,
one at the center and one at the state. There's no third category. Therefore, in fact, Delhi, in fact, had an information act before the National Information Act,
yes, sir.
and it had an information commission even before the National Information Commission. But the State Information Commission was then dissolved and was converted into wasn't dissolved, it was converted to Grievance Redressal Commission.
Right, sir.
But it ceased to be at the Right to Information Commission, and it acted in coordination with the Central Information Commission.
All right.
So the Puducherry Information Commission will now have to act together with it. If it now, of course, the state government has decided to abolish it, it is the right of the Central Home Ministry to abolish it. But if it decided to retain it, it would have to function as a subsidiary of the Central Information. Like, for example, in J&K now, J&K has been declared a union territory. 2 union territories, in fact. Those 2 union territories now, and the Central Information Commission has moved fast in ensuring that its jurisdiction is extended to the state, to the union territory, so that the people, the appeals and others, the complaints which are pending before the State Information Commission have now been transferred to the Central Information. So It functioned smoothly because of the fact that I myself had been the Central Information Commissioner and I was from the J&K state government, the state cadre, and so I worked with the Central Information Commission, the existing Central Information Commission, to do this. And now that is in fact a model of how, after the declaration of the State of the Union territory, how the organizations like the Human Rights Commission and all can all be made to work under the aegis of the central or institutions of that nation.
All right, sir. Thank you so much, sir.
Not at all.
Yeah, Bhumika, next question.
Yes, sir. So the next question is, to what extent can the definition of public authority be extended with regard to government-owned stakes in a particular institution?
Well, you see, anything that is government owned, in any case, requires to be answerable under the Right to Information Act. Now, how that is done, the information which is, if the institution itself is a public authority, because of how much the government, the stakes of the government in that authority. And this I would not like to lay down general terms. It will have to be done from a case-to-case basis. And on the basis of what the law lays down. And the law, and supported by judicial pronouncement as to what amounts to substantial, I read out to you, substantially financed. Now, what amounts to substantially financed? All those are issues that have to be seen. But in any case, the amount of money that is government money in even a private organization, it can be accessible. Information regarding that amount can be accessible either to that private organization who can appoint a public information officer to deal with that particular subject, or by the parent organization, whose public information officer will be authorized to provide information regarding that private body in its use of the funds provided by the Senate. But in no case will those funds be outside the pale, or the use of those funds be outside the pale of the RT Act. In no case.
So if we still have more time.
Yeah. If you have questions, we can take up 2 more questions.
We have one question as to, so what are the other effective ways in which RTI can be further advanced in order to make it more effective?
The effectiveness of this RTI, our RTI is interesting. Other RTIs have come after us, like for example, I mentioned Bangladesh, you have Indonesia, you have Afghanistan. They've all been modeled on our law, and in fact are more advanced than our law. In fact, the one that is considered to be the best of all RTIs, at least last time I saw it, is the one in Bulgaria. But I would be still confident in saying that one of the most effective RTIs anywhere in the world is the Indian RTI. Now, why the Indian RTI? Am I boasting that, well, you see, because I was the first chief information commissioner? No, not quite. The real reason why it is so effective is the sense of public participation. The public participating. Now, you'll find this a bit amusing. I mentioned it in that TV discussion that we were having the other day on the question of contempt of court. In India, as I mentioned to you in my discussion, the initiation of this whole movement towards an RT Act came from the public. After it came into force, the public kept a close eye on that, to the extent that a huge debate was carried on in the public. And I kept myself completely open on this business, on the basis of this idea of transparency. At that time, I do know that people were a little cautious about disclosing their cell phone number and disclosing their email. We had a public email and a private email. I disclosed it all. And in consequence of that, I got a lot of mails from NGOs, individuals. Many of them are still continuing to send me mails. But in those days, the mails often were highly abusive. Highly abusive. Corruption was one of the lesser charges. Anti-national. Pro-Pakistan. Things like that I was hearing. But I mentioned in that TV debate also, that I would take the trouble of going through those. When I took over as Chief Information Commissioner, I thought, ye kya kaam hai? The government, you can get whatever information you want. I was thinking of my own experience in working in government, that I would provide information whenever anyone asked me. So I thought that's not really a problem. I didn't realize then that by the time a person reached me to ask for the information, he'd already gone over one obstacle after another. To reaching me itself was a major issue. That is all now eliminated by the right to information. And that, an impediment must not be put in there. Even if it means that I have to listen to any abuse or galis or anything. Because that is bound to be the case. जब एक आदमी के सामने ये नजर आए कि देखिए ये बड़ा वरिष्ठ अधिकारी अपने को समझता था, बैठा था कुर्सी पे, अब इसको मुझे जवाब देना है, चलो उसको गालियां सुनाते हैं. Quite possible. मुझे भी ये समझना चाहिए. And those people, many of them, who actually were very strong critics of mine, including, of course, he never used any abuse, but he was a very strong critic. Mr. Arvind Kejriwal, today the Chief Minister of Delhi, he now tells me that I was his guru. Because I listened to what he had to say, even though at that time I kept on contradicting him. But he felt that I listened. And he put up a kiosk, in fact, in front of my office. And he would, anyone who came to say with an RTI application, he would call them in and say, did you get your answer? If you didn't get your answer, make a complaint. And he would send the complaint inside the office. So all that happened. But was that something, a weakness in the implementation? No, I think that was a strength. So the point is that public participation in this law is what gives Indian law its strength. And that must in no way be allowed to be compromised. Information commissioners can come and information commissioners will go. You'll find one better than the other. And already there have been so many, and so many are far better than I am. But the people, their interests must not flag. If the people lose interest in the act.
That's very true. You have said, sir. I want to ask you. Can you please share with us any of your own examples where some question is being asked, which is something you wanted to share during your time, something has asked to you and how to give the reply and it was difficult or something like that, somewhere where you have faced some problem?
Well, you see, a very simple, and I'll give you a very simple example of question asked and answer given, which shows the effectiveness of the law. Shortly after I had taken over, there was one application which came to me from a slum dweller. Neela Gumbad is a slum area in Delhi. So one old lady, a widow, she had made a complaint to me. And the complaint was that she simply asked that whether she was eligible for, I think it was for pension, that what had happened to her application for oil, for cooking oil. That she'd made an application, what has happened to that? Simple question. She was made to move from one office to another. She went, she put in an application in one. She said, no, this is not the right office to put it in. You go to such and such office, which is the other end of town. She went to the other office. Other office said, this information we can't give you because this is concerning somebody, this is concerning another department. So the first one could have told her it was a different department. No, they didn't. As I was telling you earlier, people have to go from department to department to some other department. So she had to move to a number of places, and then she gave in the application, and then she didn't get any answer. So then for 10 or 15 days. So then she came to me and complained that this is what had happened. Now I then issued a notice. Before the notice period had even expired, And she got the information that was given, and she said your application has been received, and this much kerosene, you can come and receive it at this time of year. So she then moved a complaint before me. Her complaint was already before me. And when the first hearing was held, the people came from all sides, and she was there, and one other NGO was also there who was helping her, and the people from the department. The department said, no, you see, the application was on such and such date, and we have provided the answer within the stipulated time, so that there's no violation of the law, and this complaint should be dismissed. So she said, yes, I've got the information that I asked for. But the difficulty is, I had applied here. I'm a poor woman. I've got no grandchildren. I've got no children at all. I live by myself. I had to move from one place to another. I had to take a bus. The bus fare was 100 rupees, 150 rupees, or something or other. I'm not earning any money at all. And I have to pay out of my whatever meager income I had. So this is the complaint that I had. So on that basis, I then gave a ruling that, okay, the question was, so far as the appeal is concerned, there was no appeal, it was a complaint. So far as the application is concerned, it was answered in time, and therefore there's no complaint regarding that. But she has been forced to do this, and therefore compensation should be paid to her for the time for the money that she spent and the time that she has lost. That kind of thing, that very simple ruling made a huge impact for many reasons. There was this one widow from sari-clad widow with a very tattered sari, who was from this sitting on the same desk as me with a senior officer of the food and supplies department. I think he was a deputy director. He would not have even probably allowed her into his office. And they were sitting at the same desk. And she was asking him questions in front of him. And he had to answer. This is an instance which I often cite of an example of the power of the RTI. How, and in answer to your issue also, of how it makes democracy real. What is a democracy? Democracy is my having to answer, the person in authority having to answer common folk, not having to answer Mr. Ambani or Mr. Tata, but having to answer the old woman in the Neela Gupta.
Yes. So that in real sense is what is the power of RTI, I may say so.
And another instance which you as judiciary would probably find amusing is that Subhash Agarwal had moved an application with me, an appeal. He had moved an application with an RTI application with the High Court, seeking, or the Supreme Court, seeking information on the property statements of all the judges.
Yeah. That's what.
You know that. You know that case.
2019, the final judgment came.
Oh no, that's another judgment. That's part of the judgment. Initial,
even that judgment I remember very well.
The initial case was simply a question of property statements of judges. And this is interesting for you in light of the 2019 judgment.
Yes, please.
The question was the property statement, because the Chief Justice had held a meeting of High Court judges, of all the justices of the High Court and the Supreme Court, to discuss this question, and the consensus was that the judges should all submit their property statements to the Chief Justice of India. So the question simply was that in compliance with this meeting of the Chief Justice, how many judges have submitted their property statement? And who are the judges? Not even a question of who are the judges who've given the property statement, and even the names of the judges who have given the property. Simply how many judges have given their property statement. Now, the Supreme Court, in its wisdom, had rejected that this question cannot be asked, because this is private information which cannot be asked. And it cannot be asked from the judiciary at all. The question came to me, and I was a single member at this bench at that point in the Central Information Commission, and I ruled that no, this property statement is something, and in compliance with its own directions, the Supreme Court must place these property statements on their website. So this was the decision. The Supreme Court, instead of saying that the Supreme Court then challenged my decision in the Delhi High Court.
Yes.
So I think it is the first time. You'll be better and more knowledgeable on this. It's the first time that the decision of a subordinate court was challenged through a PIL by the Supreme Court before the High Court of Delhi.
Registrar General of the Supreme Court has challenged.
That's right, Registrar General. Now the Justice Ravindra Bhatt was the Justice of the High Court of Delhi, who, in his very comprehensive judgment, ruled that the Supreme Court comes under the RTI Act, and therefore all this information has to be disclosed. And this is, mind you, Supreme Court having accepted that yes, the property statements of the judges should be placed on the website. It said that while the property statements can be placed on the website, nobody can ask any questions regarding the property statement because of fiduciary relationship and all that. So the Justice Ravindra Bhatt's decision, you must circulate it among your students. It gives a number of issues which come under the exemption clause. I mentioned to you the exemption clause of the RTI. It rules on one after the other of Section 8. The exemptions provided under Section 8 and what exemptions were applicable in this case. And in fact, it deals in great detail with the question of what is a fiduciary relationship. Now, the Supreme Court, not satisfied with that judgment, then went in appeal before the full bench of the High Court, and that was led by Justice A.P. Shah. And yes. Justice A.P. Shah has even given more severe. Justice Ravindra Bhatt's decision was not a particularly stern decision, but Justice A.P. Shah's decision is a stern admonition against the Supreme Court. And it's against that decision the Supreme Court went, but only to the limited extent. It considered all the other points that the High Court had laid out, but only to the limited extent of whether the private office of the Chief Justice of the Supreme Court of India comes under the RTI Act or not, on which it has now given the ruling. It's after so many years, 10 years, yes, that also comes under the RTI.
Exactly. And that is what is the judgment which came in 2019.
That's right.
Where they had asked it. And the very good example of that Neela Gumbat case, I wanted to say something on that, sir. The manner you had, passed that courageous order of imposing a fine on the person who was delayed and who has dragged this lady from one pillar to post, as we call. So that is what is your great contribution to this law. And we've seen several of your judgments, so many judgments we have seen, wherein new dimension you have given to the law. And I have no hesitation in saying so, that you and you only were as the first one to get this this entire body established and run for a good n number of years, 4 or 5 years, and established it, and then you left it. So that is what a big contribution of yours, which this nation will always remember, sir, that we know. And it is indeed excellent. What I don't have the word to thank you, that we are fortunate to have people like you who have really made this country proud. That is one thing. And second, now I would like Bhumika to please, अभी हम लोगों का मन ही नहीं कर रहा आपको छोड़ने का, लेकिन I know. Thank you very much, sir. It's indeed a pleasure, and I'm extremely sorry for the glitch what happened. Even on YouTube, we were having huge number. People are worried what happened, so we had to create another link. That is still there. But anyways, yeah, it's यही तो technical बात. Over to Bhumika.
So it was an indeed pleasure to have you with us today. And the time foundation has left us with no option, but we would love to see you again with us again. And the way the audiences, with their inquisitive questions and the way they were answered, it was a truly enriching experience to hear you out today. And we have learned a lot, and
But
definitely would love to hear you again,
yeah,
sir.
we all now
Thank you.
again somebody is writing. I'm so sorry. Vote of thank के बाद बोल रहा हूँ. Somebody is asking, what is your opinion on this the new amendment which was made by the government of India about the salaries, about the administrative, or I don't know which control, administrative control over the body. What is your
See,
views? That's the last question.
I could not really understand the logic of that amendment. Initially the RTI, even earlier, the law itself leaves a lot of deficiencies in the autonomous status of the Information Commission. It is in the interest of the Information Commission to have a completely independent institution. If the government wishes the Information Commission to function as an independent body and part of government, yes, it's not a hostile element to government, but an institution within government to keep the government adhering to its own policies. Then the government must seek to strengthen that, as it has happened with the Election Commission, Auditor General, so on and so forth. Already the weaknesses were there which we were working against, that the grants, the finances of the Information Commission were under government control, the budgetary control of the Department of Personnel. We were requesting that these should become grant funds, so that the financial autonomy of the Information Commission is maintained. We were saying, like in the case of the Information Commissioner, election commissioners, and the justices of the High Court and Supreme Court, the people who retire from the Information Commission will not then be eligible for any other appointment thereafter. Already in the Information Commission, you cannot be appointed again. You can only have one term as information.
Okay. Yeah.
That is a way of strengthening it. But the government had not introduced those features. The only feature which kept the Information Commission relatively autonomous was this question of giving it a stature equivalent to a constitutional body, like Supreme Court and High Court and Election Commission. In what way this was demeaning or detrimental to the functioning of the Election Commission, I have never been able to guess. And that is why I had strongly argued against it. Because the effects of that will not be felt now. Also, there was a lot of criticism of the Election Commission, of the Information Commission, that because most of the officers who were appointed in the Information Commission were like me, former civil servants, their first loyalty was in any case to the government, at least the system, and therefore they were incapable of functioning as autonomous bodies. Now, that was an area which I had myself recommended, that there should be a greater diversity of people appointed as information commissioners, and government had to a limited extent, but unfortunately only to a limited extent done this, that, Mr. Shailesh Kanti, who was a non-government person, and lawyers like Mr. Suryulu and others had been appointed, and justices of courts and so on. But the bulk of information commissioners, not only the center but in the states, happened to be former civil servants. So that could have been an improvement. But to bring the stature down, in what way that facilitates the functioning of the Information Commission, I fail to understand. Does it impede? It will not necessarily impede the functioning of the Information Commission now, but it could be at a future date, because if the stature of an information commissioner is no more than that of a cabinet secretary, then it brings the Information Commission into a subordinate position to the state, which I think is wrong. But that is again a question of stature and principle. It is not necessarily a question of functioning. A lot will depend on the individual who is holding that position. And I've said this frequently enough, because if you say that I was successful, it is because there were no pressures brought on me. If pressures were brought on me, I tended to ignore them. I think you may say that I'm not sensitive enough to understand a hint as a pressure. But the fact is that no pressures were actually brought, and nor would I have accepted any pressure in taking a decision. So that really depends on the individual, and that individual will therefore, whether he's a civil servant, whether he is of the constitutional stature or not constitutional stature, all these things will really hinge around the uprightness of the person concerned. So there are many secretaries to government who've taken a strong stand against the government, against the ministers, and they have been respected for it. So therefore, that in itself, the amendment, in my view, is totally unnecessary. It has certainly flawed the rules which were made in accordance with the old law, and the rules which have been redrafted are not in keeping with the rules as were originally formulated. So those difficulties have been created by that amendment, but I don't think it has really created any material difficulty in the law. The law can be and continues to be as effective as it was earlier, but as I've been repeatedly saying, it will be as effective as you and I, the people of India, want it to be and make it to be.
Thank you very much, sir. And that Neela Gumbad case, that must have now acted as deterrent for many of the officers who've been not followed. That's one thing, one big takeaway as far as the listeners are concerned. And I also want to, Bhumika would finally be thanking you. But from my, I could see there is one principal of Law College, Chanakya Law College, Deepangshi Joshi ji, Dr. Deepangshi Joshi has also joined us. Now she has just missed it. So I want to thank her also. We have from Delhi University, earlier from Hindu College, and later on, because you were in Stephens, if I'm not wrong.
I was.
I was in SRC.
Rival of Hindu College.
Yeah, so your rival, one of professor of Hindu College, Professor Vipin Malhotra was also here with us. He's still there.
I saw him, yes.
So thank you very much, sir. Bhumika, finally, you say a few words of thanks to sir.
Sir, indeed, again, it was a huge pleasure for all of us to have you with us. And it was my pleasure as well to host you over here and share the platform with you. And we'd love to have you again on the social media platform as well, so that you can always present us with your informative views, because no other Google or social media handle can give us that amount of information that we achieved today, sir. Truly enriching experience, sir. Thank you so much.
Thank you very much.
So grateful to you.
I'm at your disposal. Thanks to the COVID lockdown, I'm here, and I'd be happy to interact with you again.
Most certainly, sir. We will certainly now we will have more of a bigger question answer session, where so that because so many questions are still there, but because of the time constraint we can't do it now. Thank you very much, sir. Thank you very much from core of our hearts.
Thank you. Thank you all.
So I'm just leaving now.
Sure, sir.
Okay. You are the host. You have to close it.
Okay, sir. I'll do so.
What to do? This program is For it has become in two halves. The first half
How
was
do we
showing so extremely good.